Hey everybody, Macktion here, and I wanted to share with you some of the weekly news that you might have missed. Now, this past week, a few interesting things happened. Number one, Barnes & Noble is not going to be producing the Nook tablets anymore. It looks like after a good turn of, producing some reasonably priced, pretty good hardware tablets, it was just too much for Barnes & Noble, and they are going to be backing that off and perhaps leasing that out to other companies to produce their Nooks. The other one is, you may recall that one tablet per child thing that Thailand was doing but got held up by appeal. Well, that appeal apparently has been solved because they have announced their winners, so let us all congratulate Shenzhen Yayota Intelligent Control and Supreme Distribution for getting the bids of making combined 1.63 million tablets to be distributed through Thailand's educational system. Keep up the good work. Just don't, screw it up, guys. That'd be terrible. As we know, everybody dislikes patent trolls. I suppose the question should be, do our current efforts actually discourage patent trolls or succeed in keeping, frivolous litigation out of the courtroom? Everybody has their opinions on this, and there have been a lot of things tried to make things work more smoothly. For example, this week, there was a change to patent law that gave an extra arrow in the quiver of the United States International Trade Commission. But let's take a little bit of a history lesson and see if this makes much of a difference. In the U.S. Tariff Act of 1930, there is a Section 337, and that section states that any intellectual property infringement claim from a non-U.S. based company needs to establish significant domestic industry related to exploitation of the patent, including engineering, research and development, or licensing within the United States. Now, this does mean that you could very well have someone infringing on your intellectual property, but if you don't fulfill the domestic industry requirement, well then, we don't have to uphold your infringement case. Well, in 2010, such a case occurred where John Mezzalinga Associates had been granted during the course of their trial that their coaxial cable design patents, which they were given back in 1987, were in fact being infringed. However, at the end of the case, the US ITC said, proof of domestic industry? And they said, we've spent a lot of money in your courts. Does that count? To which the court replied, allowing patent infringement litigation alone to constitute a domestic industry would place the bar for establishing a domestic industry so low as to effectively render it meaningless. So, non-US based patent holders who don't have the domestic industry requirement can't meet it by even spending lots of money in there. They have to show related to the exploitation of the patent, including engineering, research, and development or licensing within the United States. Now, until now, that claim, that question, proof of domestic industry, came at the very end of the trial after it was determined whether or not people were infringing on your intellectual property. However, this week they changed that around. Now that comes right at the beginning. So, there are some pros and cons to this. The pros might be that perhaps there will be less court spamming from foreign-based patent trolls. Domestic ones will be just fine, though. On the con side, it does seem to be that if you can't show proof of domestic involvement, then you're not even going to make it into the courtroom to present your case that someone's infringing unlawfully on the patents that the very United States Patent Office issued to you for protecting. So I really suppose that, to be honest, from the court's perspective, it is kind of embarrassing to say, hey, you guys are in the right, but it doesn't matter because we decided a while back not to protect you if you weren't spending lots of money. Oh yeah, and lots of money on courtroom doesn't matter. Now, I've got my own personal feelings about how intellectual property claims and such should be handled, and I'm sure that you do as well. But regardless of our particular feelings about it, I'm sure we can all agree that this sounds nothing like a fair shake. Thanks for watching. I've got the links to the various items and articles, news, bits and pieces in the description. You know, I'd be interested to hear what you guys have to say about intellectual property and how you think it should be handled. So if you want to, go ahead and leave a comment below. And hey, thanks for watching.